Well, Paul, we're back again for another live stream. Excited to have another conversation. This week, we're going to be talking about some gifting strategies and maybe how to do that well for your kids or grandkids, perhaps. And excited to jump into some of the different reasons that people would do that. So I know you've got some people that typically jump on. Feel free to shout them out whenever they jump in and introduce themselves. But what I wanted to do is I wanted to talk real quick about gifting strategies or gifting reasons that are non-tax related. So why would someone be gifting to their kids or grandkids if it didn't impact them from a tax standpoint in the future?
Yeah, great question. Great to be here, by the way. The more I talk to Jacob, the more I realize things we have in common. We both like college football. We're both getting pretty used to doing these live streams together, and we both are passionate about our YouTube channel, mainly about just getting right to the point and providing good education. So it's been fun doing these with you, Jacob. Okay, let's jump right in. Gifting it's an interesting topic. There's a lot of I'll call it DIY gifters out there, people who kind of just take action because they want to and they feel it's right. In many cases, they are right. And in some cases, I'm like, boy, before you did that, I wish you would have been aware of this. So we're going to give you all those things that you will have wished you would have been aware of before you may have done some gifting. That'll come towards the end here. But yeah, there's a lot of just reasons parents want to, like to, feel compelled to give away assets to their children. And when I say give assets to their children, we could be referring to grandchildren, nieces and nephews, or other people. But most people who are doing some gifting during their lifetime, the majority of them are parents giving to their children. Here's some of the reasons people do it. One is, reasons people are aware of. You want to provide for the education for your children. You want to pay for your grandchildren's education, help them out. I was complaining to Jacob before we started. I have the good fortune of being able to cover 35 years of college expenses for my 5 children who all went to college and all either finished law school or are in law school right now. So I told Jacob I'm 31 years into my 35 years of college education between 5 kids going to school for 7 years. So I feel like I'm on the tail end. But yeah, a lot of parents like to take care of their educational expenses for their children and their grandchildren. There's some different ways to do that. Another reason people give assets to their kids is they just like to see their kids make use of and enjoy those gifted assets while the parents are still alive, and they can see the impact that they're having on their children. It just so happened, Jacob, you were telling me a story of, I think you talked to somebody today who had that very same circumstance. So love to hear more about that.
Yeah, for sure. I was on a phone call earlier with a gentleman, and he was like, Jacob, I've got money here, but I don't want to leave a legacy after I pass away. I want to leave a legacy now. So a lot of people talk about, leaving a legacy financially for their kids, grandkids, their heirs, whoever it might be, or perhaps to a church or charity, wherever's important to you. And most of the time we think about that post-death, meaning after we're not here anymore. And for him, he wanted to say, hey, I'd rather see the benefits of them receiving this money, whether it be for a wedding or buying a house or being able to do whatever they need to do with that, and perhaps start a business, whatever it is. I want to see the fruits of that gift while I can still appreciate it and be a part of it, rather than just say, I'm going to give it to them when I'm gone, but I won't be able to see that in action. So it's an interesting point, and it's something that, this is real life stuff, because I had a conversation just today on that.
Yeah, so I play around with some of that retirement projection stuff. I'm getting to be about that age where I need to worry about that kind of stuff. So I know that when parents give assets to their kids, they're balancing I want to make sure I don't spoil my kids and make sure they're reliant on my money. On the other hand, they're saying, I'd love to see, just like your client, I'd love to see my kids enjoy this. And then on the other hand, people are probably thinking, do I have enough? Can I afford? Can I financially swing it to transfer $50,000, $100,000, $200,000, maybe more to children and grandchildren, in one big swoop? So I'm guessing with those kind of Monte Carlo projections that you know a lot more about than I do, I'm figuring that parents got to be in the kind of 98% plus. This is all going to work out before they start just giving assets to their children. What are your thoughts on
for sure.
how secure should people be in their retirement plan before they start gifting?
Yeah, well, I think it's an even bigger point is that your estate plan, your retirement plan have to talk together and work together, because for them, my job and part of your job too as a estate planner is to say, how do we combine the emotional desires or the emotional things that are important to us with the dollars and just the data, right? How do we put those two things together and make it all work well to where we optimize the numbers, but also meet their desires and their emotional goals, whatever those are. And so from a retirement planning standpoint, this particular gentleman had most of their retirement income needs met from fixed sources via Social Security or a pension or some different annuity incomes. And so for him, whatever was liquid in his IRAs or brokerage accounts, that's left over. He technically didn't need from an income standpoint. All the debt's paid off. And so, hey, I'd like to give some of that to the kids while they're still young. And actually, one of the things he said was, I'd rather give it to them whenever they could use it most, rather than 30 years from now, whenever they're in my situation, they've got all the money they need anyway, right? So I'd rather help them while they need it, as opposed to just giving them more money in the future. So the estate plan and the retirement plan, or just the financial plan in general, they have to work together, because if they're doing these two things separately, it's just not the best thing ultimately for the individual.
Yeah, and we'll talk about some of those tax rules in a minute. But what I do find, and I'm sure you have, and we'll see this, especially as your clients age and start taking those required minimum distributions. A lot of people will, once they reach whatever that age is, they have to reach. It keeps changing. Then they get that required minimum distribution, and they don't need it. They take the taxes out of it if it's a traditional IRA. But they've been living fine, just like you say, Jacob, off their other income, their pension, their Social Security. And so a lot of times you'll see parents in their 70s start getting these required minimum distributions that might be $40,000, $50,000, $60,000. And they feel like, I don't really need this. I'm just going to go ahead and pass this along to the children. So I think the parents really enjoy that. Keep going here. Another reason parents give away to their kids is because some kids have needs. I've had a lot of clients who said, Paul, we've really helped out this child a lot more than we've helped out our other child or children. This particular child struggled, never were able to buy a home. So we felt like we had to, cover some of their living expenses, and we were happy to do it. But then that gets tricky, just like you say, when the financial planning and the estate planning are intertwined. If you're going to advance significant sums to one child during your lifetime, how does that affect your estate plan? Should the three children inherit equally what you have left when you pass away, or should some of those excess lifetime gifts made to one child count as part of their inheritance? So we'll be talking about that in a little bit. A couple other reasons, just people kind of DIY, tend to do it yourself, tend to put assets in other people's names, and this is a complex area, and you really don't want to go it alone, because there's a lot of mistakes being made. And I'm not saying these actions are right, wrong, or indifferent, but I've just seen a lot of people out there put assets into their children's names for potential Medicaid eligibility purposes in case they have to go into a nursing home in the future. A lot of rules on that. I'll touch on it in a little while when we talk about what you really need to know about. But the big picture is, a lot of people, kind of the middle class, fears going into a nursing home and being forced to use their life savings and ultimately lose their home if in order to pay for that nursing home care, which, depending upon where you live, could be $7,000 to $13,000 or so a month, double that if it's a married couple needing care. So a lot of people are putting their assets into their children's names, but there's some real particular rules. There's the old 5-year look back rule. We'll probably touch on that in a minute. But that's just another reason parents are putting assets into their children's names. Another reason is some parents have either heard stories or have gone through a difficult probate, and maybe they have a business or a piece of land or some assets, and they're just like, I don't want these assets frozen when I pass away. I don't want my kids to have to go get lawyers to go through a court process just so my kids can have this piece of land. Let me go ahead and put it in their name now. So right, wrong, or indifferent, we'll talk about that in a minute. I got so excited I hit my computer, so I was shaking there for a minute. And then maybe one final reason. I was talking to someone today, as a matter of fact, and they were worried about a potential liability And this wasn't their concern, but sometimes people will talk to me after they cause an automobile accident, and then everybody starts threatening lawsuits. So some people say, well, let me just put these assets. I've got this $1 million brokerage account. Let me go ahead and put that into my kids' names. I don't use it anyway. So in order to protect it in case I get sued, let me put it in their name. So those are just some of the things that are going through people's minds as they go through life and try to make a decision whether they should keep everything in their name or transfer some assets into other people's names. So there we are on that.
Yeah. So, I mean, those are a lot of the, emotional or maybe non-tax related reasons. Now, I know there are plenty of tax benefits perhaps of gifting, but also some different tax rules to think about and be aware of as well whenever doing that. And so wanted to see, like, what are some of the, I guess, main reasons that someone would try to gift while still alive, and avoid some taxes or help on the tax front, but also what are some of the things they've got to worry about too in terms of regulations there?
Yeah, there are a lot of gifts being made across the country, and people aren't complying with the tax rules that they need to comply with. Will that come back to haunt them? Maybe it will, maybe it won't. But yeah, everybody needs to at least be aware of the rules that apply when a parent makes a gift to a child. The first rule I'll talk about is what's called the $18,000 present interest annual exclusion. Everybody is confused by that rule. Most people hear in their mind, if I make a gift to someone of $18,000, they don't have to pay tax on it. But if I make a gift to someone that's more than $18,000, somebody's got to pay some tax. Actually, that's not right. Yeah. So we have a rule. We have a federal gift and estate tax exemption, just like estate planning and financial planning are so related. The gift and the estate tax are related. So when we talk about the gift tax, we have to talk about the estate tax. So the way the estate tax works for people who die in 2024, it's a big number. The first $13.61 million that they have is exempt from the 40% federal estate tax. So now let's go to gifting. We also have what is for 2024 was $17,000 last year, $18,000 this year, the $18,000 present interest annual exclusion. What that rule means is you can give $18,000 to as many people as you want to. They could be children, they could be grandchildren, they could be unrelated people. You can give $18,000 to as many people as you want to, and that's it's called a non-taxable gift. But let's say, for example, you gave $118,000 to your daughter. So that's $100,000 more than the $18,000 present interest annual exclusion. What's the tax consequences to everybody? Well, the daughter who received the $118,000 gift, she doesn't have to report that anywhere. All that is income tax-free to her. It doesn't get reported anywhere on the daughter's side. On the parent side, it's not a deduction on the income tax return. However, because let's call it dad gave $118,000 to his daughter. The first $18,000, that's okay. The extra $100,000, nobody owes any income tax. It's just dad used, by making a $118,000 gift, dad used $100,000 of his $13.61 million estate tax exemption. All that means is now when dad dies, instead of being able to leave $13.61 million free of estate tax, he can only leave $13.51 million free of estate tax. So by making a gift in excess of $18,000 to anyone in any calendar year, really, you're just starting to use some of your estate tax exemption, which most people will never use. But there is a filing requirement. If you do make a gift to someone in excess of $18,000, you're required to file. It's a gift tax return, IRS Form 709. You got to tell the IRS, tell the government, hey, I made a gift in excess of $18,000. I've used some of my estate tax exemptions. So the IRS can keep track of what those kind of major gifts that you gave during your lifetime. So again, the where that's missed is when just kind of Joe do-it-yourselfer, and I'm not criticizing Joe do-it-yourselfer. I just know that a lot of people take these matters into their own hands. They put a piece of land into their child's name because the child wants to build a house on it, or they want to help a child out with a wedding, and so they write them a check for $60,000. In all of those circumstances here, it's really incumbent on that parent who made the gift to file that gift tax return to show that they use some of their exemptions. So,
Paul, is that the part that gets missed the most, the actual filing of 709 there?
Yeah, it gets missed all the time.
Yeah.
Well, what gets missed, and some people believe that, boy, if I give more than $18,000 to my daughter, I don't think I'm going to do that because she's going to have to pay income tax on it.
Right.
They mistakenly believe that a gift in excess of the gifting limit is subject to income tax, but it really isn't. So, yeah, you can gift all you want and nobody's going to pay any tax. Yeah, you'll have to do some reporting. And then there's some other tax rules that apply as well. Let me go ahead and hit some of those real quick.
Yeah.
And this applies when not necessarily on gifts of cash. In many circumstances, if you're going to give assets to a child and you've got cash, you've got an investment account with Jacob, you've got an IRA, you've got some land, you've got a business, oftentimes it works out from a tax standpoint if you make the gifts of cash. Because just like Jacob and I were talking before we started here, if somebody bought Apple stock for, and Jacob, you may know about what Apple stock is worth these days. I'll pick that up as an example. I'm sure
$200 or something like that.
$200? Yeah.
Something like that.
Well, I saw a better one. I saw an article where if you would have purchased 10,000 shares of Nvidia stock in 1999, that stock would be worth $59 million today. Well, maybe less because it dropped by like 10%. So let's use that example just for kicks and just to be fun. So let's say you bought $10,000 of Nvidia stock in 1999. And today that stock is worth $59 million. Never heard anybody with that much gain. But a man can dream. So if you happen to say, you know what, let me just put that stock into my kids' names now, avoid all the hassle when I pass away. Well, when you gift appreciated assets to your children, or to anyone for that matter, we call them donees or recipients of the gifts, they receive that stock at what's called a carryover basis. So when Dad purchased that Nvidia stock in 1999 for $10,000, that's his basis. It grew to $59 million. But if he gives that stock to his kids while he's alive, not only does he have some gift tax reporting to do, but his kid's basis in that stock will be the $10,000. It's that carryover basis what Dad paid for it. However, if Dad leaves the stock, keeps it in his name, leaves that stock to his kids when he passes away, or leaves that stock to anyone, then the recipients of that stock, the inheritors of that stock, inherit that stock at a stepped up basis. The recipient's basis will be the value of the stock on the date that Dad died. So instead of a $10,000 basis, it's a $60 million basis. You can imagine the capital gains tax that gets avoided in that scenario, which is extreme. But even in the non-extreme cases, you really need to think twice before you gift appreciated assets, because people who understand this rule, a lot of they are hardcore, and they'll be like, Paul, there is no way I'm going to give this asset to my children while I'm alive. Sure, I want them to have it. However, they're going to lose out on that step up in basis if I give it to them while alive. So I'll give away other assets, and I'm going to keep ownership of this land, this business, this stock. Let them inherit it at the stepped up basis. So the perfect scenario, because if you keep the asset in your estate, it's subject to estate tax if the estate is large enough. And in many cases, it's not. So the kind of ideal scenario is sometimes there's a penalty to the family for making a gift of an appreciated asset. The ideal scenario is, let's say you got a guy with $10 million, a $13.6 million estate tax exemption. He's asking me, Paul, should I go ahead and give a bunch of these assets to my kids? I'm like, maybe not. Why don't you keep all of it in your estate? Let it all get the step up in basis. There's going to be no estate tax when you die because you're under the 13.61 million, although that exemption is going to be cut in half in a couple of years. So that makes the conversation more interesting. My point is, sometimes it's advantageous to the family to keep an asset in the estate so long as there's not going to be a 40% estate tax applied to it. in order to preserve the step up in basis. That was a mouthful. I got to take a breath, Jacob. You're on.
Yeah. Something I was going through my mind there was, let's say that someone wanted to gift to their children, but also gift to a charity, let's say in retirement, and they have some appreciated stock in a brokerage account. And they have some other assets at different places too. Going to the financial planning side of that, right? If we're going to gift to both of those spots at the same time, let's say in one particular year, giving the appropriate type of asset or security to the appropriate recipient is important, right? Because those appreciated stock holdings, whatever it might be, those should likely go to, or I would say most likely go to the charity, because they do not pay those taxes at all, as opposed to the other items you could give to your kids at a lower impact there.
Yeah, I wrote an article on LinkedIn recently. Do you see my articles on LinkedIn by chance, Jacob? You
I
got to
do,
subscribe.
yes.
You get them?
I do.
Okay, good. So I did one on, you talk about giving appreciated stock or appreciated assets to charity. I've been involved with some really, really cool family scenarios where a donor set up a donor advised fund.
Yeah.
It's a great vehicle, especially it kind of combines the financial planning and the retirement planning and the charitable planning with the estate planning. Great way where you get the immediate tax deduction by transferring appreciated assets to your donor advised fund. The fund can sell the assets, incur no capital gains tax. And then you can just take your time directing assets from that donor advised fund to the charities of your choice. Very efficient. And what I like about it is if there's any funds remaining in the donor advised fund when you pass away, you can designate who has the right after you pass away to designate which charities those funds go to from your donor advised fund. So that's a great way to get the family involved in your charitable giving by setting up a donor advised fund. Very efficient, very cost effective, eliminating all of the administrative costs of setting up your own charity and your own foundation. Just eliminates all of that administrative hassle. So yeah, a lot of gifting, wise gifting is done by gifting appreciated assets. Once they're transferred to the charity or the donor advised fund, those charities or those donor advised funds can sell the stock. They don't pay any tax, so all that capital gains tax gets avoided. So good point there.
Those donor advised funds are very powerful for even like amongst all the other tax planning items or different strategies you can put in play, because you can do what's called bunching. You just referred to it. You could bunch all of your charitable gifts. If you planned on giving $100,000 to a charity over the next 10 years, take $1 million, put it in at one time. Now you've got $1 million of deductions you can offset this year against other potential income that you might create, such as, doing a Roth conversion, maybe at a business, payout or whatever it might be. Now you don't pay any income tax on this other stuff that you're offsetting against that donor advised fund because you were going to give it anyway, right? So let's put it in the donor advised fund now and give them $100,000 over the next 10 years. And on top of that, you can invest that money inside of the donor advised fund, and then it grows to be more than $100,000 total. And so the charity benefits, that much even more. So it's pretty cool account. So if something that could apply,
love those things. Yeah, love them. All right, one more piece on the step up in basis and the gifting of appreciated assets. There's about 9 community property states. And what I'm about to tell you is sometimes a married couple, it can save the family a lot of tax if they wait and do any significant gifting until one spouse dies. So for example, in our 9 community property states that really start around Louisiana and go west and then go up north, when one spouse dies, all of the community property gets a step up in basis, which is a tremendous advantage. So if they bought that stock as community property and the spouse dies, not only does the deceased give up in basis, but the surviving spouses gets a step up in basis. Big tax benefit. And so if you're in a non-community property state, then for example, if the husband dies, only his portion of that Nvidia stock gets the step up in basis. But so oftentimes right after one spouse dies, if the surviving spouse feels like they have enough money to live off of, then that's a great time for the surviving spouse to start doing some gifting of those assets that got the step up in basis when the first spouse dies. So A lot of step up and basis, carryover basis stuff. But again, hopefully you're just learning some things and keep them in your back pocket before you start taking some big action.
Yeah, well, that's great, Paul. So those are a few different reasons that we can, start using some gifting, whether it be for the tax purposes or the actual financial purposes, or just because we want to give to our kids or grandkids and help them in whatever ways we can. How do we do this well? I mean, we hit on some of these things, but what are the things we need to know or be aware of, and how do we do all this really well?
Yeah, so I would say one thing I think our viewers would want to see is when someone is doing that gifting to avoid estate tax, and that's for the person who now may have assets approaching 13.61 million, but that $13.6 million exemption is going to be cut in half in 2 years, going to be cut back to around $7 million. If someone has, they're approaching that or they exceed that, then kind of estate tax planning 101 for those estates that are going to be subject to estate tax is typically, let's start giving $18,000 to as many people as we can. Children, grandchildren, great-grandchildren. If you have 10 descendants and you're married, each spouse can give $18,000. So that's giving $36,000 to each of your 10 descendants. Every year you can take $360,000 out of your estate year after year after year, not using any of your exemption. That fund, which they could set up at your office, Jacob, for all those descendants, it could grow to millions of dollars that would pass free of estate tax. Now, a lot of people don't like the idea of just dumping $36,000 into each grandchild's lap, especially if they're young and, they're not mature yet. So making those gifts to what us estate lawyers called crummy trusts, crummy is the word after a court case from many years ago, where you put it in a trust and you have to give them what's called a crummy right that we could talk about later, or you could Google it. But we have to give them a temporary right to take the gift. But if they don't take the gift, then that gift is kind of locked up in trust under the trust terms. And then that child or grandchild or great-grandchild doesn't get those assets until the trust says they get it, which is probably later in the life when they're much more responsible and adult. So gifting, instead of just outright gifting, sometimes gifting in trust makes more sense in order to have a little bit more control over those assets after they're gifted away. Some people mistakenly believe when it comes to the old, let me get my assets out of my name for Medicaid eligibility purposes because I'm 75 years old. My mother went into a nursing home and was there for 7 years. She lost everything. I'm 70 now. I'm not getting any younger. I don't plan to go to a nursing home, but if I do, I don't want to lose everything. Some people mistakenly combine some of these tax rules with the Medicaid eligibility rules. So some, 70-year-olds who have maybe $500,000, they're like, let me just start giving $18,000 to each of my 3 children and whittle down that way. Well, the person with $500,000 doesn't have to worry about this unified gift and estate tax structure. And they're not really helping themselves out by giving away $18,000 year after year while they're 70, 71, 72, 73. Because in order to qualify for long-term care Medicaid, you have to, when you go into a nursing home, have less than $2,000 and have made no gifts in the previous 5 years. Mm-hmm. So for this Medicaid eligibility purposes stuff, you got to give it all away. You can't do it in little increments. You got to give it all away and then hope you don't go into a nursing home for at least 5 years. Now, when those parents give it all away, they often don't like the idea of, okay, I've got 3 kids. Let me give each of them $200,000. I've got this one child who's not really responsible. I don't want them to blow it. So that's why they'll put their assets into very particular types of irrevocable trust that they can't undo, but they meet the Medicaid rules. So it's a way to get assets out of your name for Medicaid eligibility purposes. But again, because you're putting them into a trust and maybe naming one trustee who manages that for the rest of your life, it's a way for you to really retain more control over those assets after they've been given away.
Yep.
Couple of other points. Feel free to jump in, Jacob. I hate to monopolize all these conversations, but like I said earlier, I get so excited. I hit my laptop and it jumps up and down. So
I love hearing all this. It's
yeah.
very
So
helpful.
if you are making gifts, and a lot of people are out there, they're helping their daughter buy a house. It's housing's out the roof. Children can't save enough to make a down payment. Lots of parents doing that. So if you do that for one child, I mentioned this earlier, you don't want to destroy family relationships by not having this conversation, by not communicating. Let's say you did give that child $100,000 and you didn't give it to your other two children. So you have an estate planning decision to make. Will that $100,000 that you give to your daughter count as part of her inheritance? So she receives $100,000 less when you pass away? Or do you feel like, you know what we do during our lifetime and they can all share equally with what we have when we pass away? There's no right or wrong here, but I think it's important that you make an informed decision, and maybe even better that you communicate the why of the decision to those children so that when it comes time to settle the estate, they're all like, yeah, mom and dad told us that they gave my sister $100,000 and they told us that they didn't want us to hold it against her but they just felt like that was the right thing to do. And so we want to support mom and dad's intentions there. So that's a big one. Yeah. We've talked at pretty good length about the just be aware. That's just what I want people to walk away from this video. Be aware that if, gifting is great. I'm all for it. Parents for exactly the reasons, Jacob, you mentioned earlier, parents able to see their children enjoy the impact of the gift. And so, but just be aware that we have this carryover basis on gifts of appreciated assets, step up in basis on inherited assets. Make sure your gifts are thought through, and then be really careful. You get in that fender bender, you signed a personal guarantee for a business, and now you're like, oh, geez, I might get sued one day. A lot of people mistakenly believe that, geez, I just got in a bad wreck and all these personal injury lawyers were on the scene. I'm probably going to get sued. Let me put all these assets into my kids' names. A lot of people think that those assets are protected as long as they put those assets in the kids' names before they get sued. But really the way the rules are, if that action that could cause a lawsuit, the automobile accident, if it took place and then you transferred the assets, even if you transferred the assets before a lawsuit was filed, that could be considered a fraudulent conveyance, a transfer with the intent to defraud creditors, and creditors could undo that transfer and really make life a real mess. So just another thing to be aware of, keep it in your back pocket. Hopefully you don't have a situation in life where you feel like, you need to be aware of that, but it comes up a lot these days. So be aware of it. Yeah. So, all right. So yeah, those are, I would say, some of the just emotional, like you say, reasons people gift, Jacob, and then some of the tax rules, and then kind of what are some of the things you should know.
Wonderful.
What are your thoughts on all that, Jacob?
No, it's great. Very helpful. Lots of information there, but it's super good because it helps people understand that it's more than just giving money away to somebody, and that's good, right? Because if you do some things incorrectly, could come back to bite you a little bit. But I'm curious, do you have any questions on coming in from folks on your side?
Let's see. Let me
we got Larry here with us. Hey, Larry, glad to have you.
Hey, Larry.
Let's see. We've got Paul. We got Mark. Mark, glad to have you as well. And then Paul, we got a question here from, looks like Richie. What happens if you don't file that gift tax form?
Great question. I almost wish I didn't have to answer it because what's likely going to happen if you don't file a 709? Probably nothing. Yeah. Because I've looked at this in some great detail, and the penalties for failure to file a gift tax return were really copied from the penalties for failure to file an income tax return and pay the tax. So the failure to file a gift tax return, at least at the federal level, there's a handful of states that have their own gift tax, not many, probably count them on one hand. So I'm not speaking for those particular states that may have a gift tax. But really, the penalty for failing to file a gift tax return is a percentage of the tax that wasn't paid. And so if somebody makes a $2 million gift, you're sure the first $18,000 is exempt, but they really just use $2 million of their estate tax exemption. There's no tax due.
Yeah.
So if the penalty is a percentage of the unpaid tax, well, there's no penalty because there's no tax due. So I kind of hesitate to tell you that, but I had to because you asked the question, just to kind of, I don't want people to think, no big deal, because maybe they could change the rules or whatever. But and in general, I think people want to comply with the rules if they can, and they're fairly easy to comply with.
Yeah.
All right, let's see here on real quick here. I had to pop into these. I think I don't know. I don't see any, but I think it's because I don't know what I'm doing from a technology standpoint.
Well, no worries. We can check them out later if they're popped there into the comment section. So Paul, this was fun.
Yeah. So hope you enjoy the recording, guys out there, and got to know Jacob really well, and I want to encourage you to take advantage of whatever he offers, conversations, whatever. I know he's really busy, and is actually, I've learned a lot from his YouTube channel. So looking forward to more of these in the future.
Yeah, great. Same for my viewers on my side. Go check Paul out if you need estate planning help or just conversation. He's happy to help. So Paul, this was fun. We'll do it again here in a couple of weeks, I think, right?
Yeah, sounds great, Jacob.
Okay. All right. We'll see you next time.
Okay.